Good afternoon, everybody. Welcome to Merhab Robinson and Clarkson's Ask the Attorney webinar for February 2026. Today, the presenters are going to be myself and Cassidy Russell. As a reminder, our firm does estate planning, probate, trust administration, business law, formations of businesses, and anything for the employer, the business owner. Here's a little bit of background. Cassidy and I are both the estate planning attorneys. Primarily, Cassidy focuses on estate planning, and I focus on planning and trust administration in the firm. So today we're going to try to just make it an educational and conversational webinar. Nothing is scripted. Just so ask any questions that you have. We already have a list of questions, so we're going to go ahead and start with those people that submitted them prior, but there's going to be an opportunity as well for you to answer questions during the webinar. But we do ask that you keep it limited to estate planning, probate, trust administration, as that is our specialty. And just for your information, this is a public forum. We are going to post it on our YouTube page and so forth. So if you want to keep things private, we completely understand. You can submit your questions anonymously, or if you do raise your hand, then we will keep it private. And we can always schedule a separate consultation to go over in more detail about your specific instance. Obviously, we can only give certain advice with the little bit of information or questions that we're getting right now. So as I mentioned, we're going to start with the information that we have, the live questions, but feel free to raise your hand. Even, if you don't want to put your name and you put a number or a fake name, we'll go by that. Or like I said, submit them in the Q&A feature for anonymous questions. So we're going to go ahead and get started. I'm going to put Cassidy and I both on the screen so we can just go with what's been started so far. So one of the first questions that we got, should I put my timeshare in a living trust? Yes. So the question though then is, how is your timeshare held? Some timeshares hold it as a deed, and other timeshares you may have a points ownership interest. So the best thing to do is to talk to the owner of the timeshare company, because we have a lot of them. Even though the property may be in California, a lot of the timeshare companies are out of Florida. So oftentimes it's best to work with them, and we'll be happy to coordinate that with you as well. And then sometimes we have clients that have timeshares in Mexico. We cannot do international law. So my preference is always that you reach out to the owner of the timeshare administrator and find out what their requirements are and how we can put that in the trust. And by putting it in the trust, that allows your successor trustee to be able to administer it, either sell it, distribute it to one of the beneficiaries, and so forth, after you pass or become incapacitated, to make it a little bit easier. Okay.
We get a lot of timeshare questions, and especially during trust admin, we're always wondering if they're in the trust. So that's a good one to start with. And then the second one we got here was, it says, I reside between two condos across two states, one in California and the other in Oklahoma. I spend more time in Oklahoma. If I leave the California condo to my daughter, will that qualify as passing my primary residence and get the stepped up basis? Okay. So I see a few different issues here. One of those being, where should you get your estate planning done in the first place? And I'm going to say it's going to depend a little bit on what you consider to be your actual primary permanent residence. That's going to affect that. And it will also affect some of your power of attorney and healthcare documents and things like that, as those are state specific. And then as far as leaving the condo to your daughter to get the stepped up basis, it sounds like if you're spending more time in Oklahoma, that you've actually established that that is your primary residence. And so it wouldn't qualify for the property tax reassessment exemption that is from primary residence of a parent to primary residence of a child. There's a certain portion that you can protect from reassessment. So just on this limited information, I would say probably not, based on the information you've given us. But if you want to talk more specific, we could get into the details there too.
Yeah. in the basis information, regardless of where your personal residence is located or your primary residence, what state of residence, all assets that you own at date of death that are subject to estate tax would get a basis step up. Whether you owe estate tax or not, it's a different question. It's just whether they're subject to estate tax. And California is very strict. So I would imagine that, making sure that, what state is your primary residence for income tax purposes is very important, and that California for property taxes would not be comfortable if Oklahoma is your primary residence for tax purposes, but then you say that California is your primary residence for property tax purposes. So they're a bit contradictory. Okay. Next question is, how do I expense the cost of my trust to my business? My CPA says I cannot expense the cost personally. Your CPA is correct. So unless you're doing succession planning for the business, technically your personal estate planning documents are not subject to a deduction in your business. So they're considered a personal expense.
Okay, so the next one here we have are, what are the risks of having some assets in my personal name versus being in my trust? Would they go into probate, and will that create a problem for my family? So I'm going to kind of break these down a little bit. Some of the risks of having some assets in your personal name versus being in your trust. Well, biggest one being if we add up all the assets that are in your personal name that don't have beneficiaries and aren't in your trust, we want to make sure that we're not getting anywhere close to that probate threshold, which is $208,850. And that adds up rather quickly. And if we all of a sudden get there and then pass away, we do have a probate problem. We actually have a trust administration right now where there was one account and we were really close. And then all of a sudden we found another account and we were going to probate. So it very quickly can add up to the probate threshold and require your family to go through probate. So that's something that we want to be sure of taking extra care of. And then also with the incapacity planning that we put in place with your trust, it provides for very specific details about how your trustee is supposed to use those assets to provide for your care during your lifetime, including being able to use those assets for the care and benefit of your spouse or your dependents, things like that. So it just gets more fleshed out within your trust than to just have a beneficiary named on the account as well. Okay. And then would they go into probate, and will that create problems for my family? Like I said, it's possible that they would go through probate depending on the value of them. Non-retirement accounts are specifically what I'm talking about. So life insurance and retirement are handled through beneficiary designation. So we're going to exclude that from that calculation as long as you have proper beneficiaries named. But we want to make sure that the aggregate or the total amount is less than that 208,000 approximately. Okay. And whether or not it creates problems for your family, it depends on how much you like probate court. And I can personally tell you, I don't really like it that much. Even going through it as a professional, it's very complicated, it's very costly, and it's a very lengthy process that your family wouldn't want to go through. And then what should be done to get assets from my personal name into my trust, and are there any taxes to be considered by doing that? Okay. So it depends on the kind of asset for how you want to get it into your trust. We help people with deeds and making sure that their real property are titled into their trust properly. At least in California, we can get you to the right people in other states, but they do deeds a little differently in some of the other states, whether it's a different kind of deed or just some of the forms that they require with those deeds. But we want to make sure that the real property is titled properly. With bank accounts, non-retirement accounts, it's usually pretty simple. We ask you to take a few sets of documents to the bank and tell them to retitle that bank account into the name of the trust. Most of them are very good about that. Some of them give us a little trouble. And so those are the ones that we actually guide you to name the trust as a beneficiary instead of retitling it, because they like to meet their quota of opening new accounts for people. So I just had a phone call about vehicles. I always joke with people, unless you have a Jay Leno asset where your car keeps going up and up in value, most of us don't need to put our cars in the name of our trust. But some of us have collector's cars where the value is over that probate threshold, and that's where we may need a DMV or a AAA trip to get those titled in the name of the trust as well. So those are the few different things I can think of off the top of my head. Besides your personal property, we get those assigned to your trust, and that pretty much covers furniture, clothing, all of that kind of stuff as well. So.
Also, if you have, for example, your checking account, and let's say it has $20,000, which is way below the probate threshold, but it's in your name alone and you pass away, then there is a process to avoid probate, but your trustee has to wait 40 days to collect those assets, because they take an affidavit, it's called an affidavit of small estate, to the institution and make certain declarations. So that 40 days could be a problem. I mean, usually with vehicles, if it's just a normal car, not a big deal to wait the 40 days. But if you're dealing with liquidity, that could hinder your estate, maybe not have some money available to your trustee to start paying bills, reimburse themselves for funeral expenses, different things like that. So we do recommend that, all of your financial accounts are named in the trust. Like Cassidy said, retirement plans, life insurance should have beneficiary designations, and whether those are the trust or individuals is dependent on your specific situation. Okay, so next question. How do readings of the will work? Is it like on TV where the entire family gets together? Well, this is a very, very common question, but no, there is, I don't think I've ever done a reading of the will. So in California, the process, when someone passes away and they have a trust, the successor trustee within 90 days of the death, 60 or 90. We always do
60.
it right away, so it's never an issue. But they are required to send out a notification of trustee to all of the heirs at law, the decedent's, children, spouse, whoever might be the heir at law, and any beneficiaries in the trust, and send a copy of the trust document to the beneficiaries. So we like to get that out right away. If the assets are going through probate, then once the probate petition is filed, notice of the hearing is sent out to all of the heirs at law, as well as beneficiaries named in the will, which also includes a copy of the will. So the reason that we don't necessarily do readings of the will is because our job as the attorneys is to advise the executor, to advise the trustee. And when you start bringing in all the beneficiaries, they start thinking that we're representing them. And there's inherently a conflict of interest. So they're entitled to go seek counsel of their own. And that's fine, but generally we do not bring in the whole family to go through a reading of the will. We would be happy to do it if somebody wanted to. I'd say most of the time when we're going over the estate plans with people is when the parents are alive and we're bringing in the kids, and they're like, can you just explain to the kids ahead of time what's going to happen and everything? So it's more of a living thing versus after someone passes away.
Yeah, we think of the movies like Knives Out and stuff, and it sounds interesting, but it also sounds like a big problem waiting to happen. So, okay. Next question. I don't like my daughter's husband. How can I protect her inheritance from him? Okay, well, this is not as uncommon as you think. And even if we do or don't like our child's spouse, we can still want to protect their inheritance. We want to make sure that if something goes wrong, if they have an incident where they're sued or where they're going through a divorce, things like that, that their inheritance is protected. And we can build in protections into your trust to be able to make sure that they are a little bit separate from what could be subject to a divorce or to a lawsuit or creditor and things like that. It's just a special way of doing your planning, and we can talk through it with each of our individual clients. But it's a very common question, and I would say 98% of my clients, at least, don't plan for their in-laws. And I'm a daughter-in-law, and I don't expect to receive anything either. And it's very easy for us to build in those protections for you if that's something you'd want to do.
Yeah, and legally, when someone, if your daughter receives assets from you, they are legally her separate property. They are not a community property asset unless they are left to both your daughter and son-in-law. As Cassie mentioned, the easiest way we usually do it is through what we call a dynasty trust. Basically, in your estate plan, you're creating an irrevocable trust for the benefit of your daughter so that those assets are very clearly separate property. Because if you name your daughter as the beneficiary, let's say you leave her a $250,000 account, she can legally separate that. It's her separate property. Go open a separate account in her name only. She can open up a separate property trust. We have lots of clients that do that. And that's a great way to make sure it's kept separate. But she can also choose to commingle it with her spouse if she wants to. So if you really want to keep it separate, I would say within your own estate plan, we create a dynasty trust where all the assets that you're leaving to her are there. She can be the trustee of that share, or you can name somebody else if that is a concern for it. Can I fire a trustee if they are not doing a good job? That depends. Okay, so if your trust is revocable, I would assume most of the time, if you create your trust, it's revocable, that you're probably serving as trustee most of the time. If for some reason you appoint a co-trustee, like sometimes we'll have clients appoint a child that helps them out and things like that, as long as you have capacity and it's revocable, you're able to change your trustee at any point. Okay, that's not a problem. But if we're in a position where, let's say, mom and dad have died, and we have child number one is the trustee, and child 2 and 3 are not happy with that person, it's a little bit more difficult to remove them. The first thing that we have to look at is, what does the trust document say? And there are some times where the trust documents will say, the majority of the beneficiaries can remove or replace the trustees periodically, and things like that. But generally, this is a conversation we have with the parents. You want to trust the person, and if there's any doubt, don't name them as trustee. But if the parents have named child one as the trustee, that's who they want to do it. So barring the child, breaching their fiduciary duty as trustee, by stealing the money, favoring another beneficiary, you're really just kind of stuck with them. However, the beneficiaries do have recourse, if there is that breach or, some other malfeasance type of action, the beneficiaries can file a petition with the county court to have that trustee removed. So sometimes family pressure will get them removed, but that's the legal way to do it. And remember, when we have trustees, like if child one is the trustee, they are required to give an accounting to child 2 and 3. So child 2 and 3 can see exactly what they're doing, can get support for all of that. And by accounting, we mean, here's the value on mom and dad's date of death. Here's the money that's come in or has gone out since then for the expenses and things like that. And then what's left to divide, including the trustee fee that the trustee took. So if there's any issues with that, then usually we start by asking questions to clarify it, or if it comes to the need, then the trustees can file a petition with the court to have them removed, or at that point in time.
Okay, so this next group of questions is kind of our IRA specific questions. It looks like a little group came through together on these. And I was just having this conversation with one of our paralegals. Is my trust a see-through trust? If not, can it be converted to one? So a see-through trust, first off, it has specific requirements within the law of what you have to have for it to be a see-through trust. It requires that it's irrevocable upon the death of the creator. The specific named beneficiaries are identifiable, and then certain paperwork has to be given to the account administrator before October 31st of that year that the person passes away. And I will say that when we draft revocable living trusts, they do have see-through trust provisions within them, but it's going to depend on the specific trust document itself as to whether or not it provides for that. And then we also have some other questions about that. So if yes, then does the IRA account go to trust and does not need multiple beneficiaries listed for it? So typically when we're going through the funding process with our clients, we advise them about how to name a beneficiary on an IRA. And it's going to depend on certain family situations how we do that. Typically, if people's children are adults, they're financially responsible and capable, we're going to have you name your children as the backup beneficiary to your spouse, and they would receive it and be able to roll it over and do things with that. Why? Because it gets better tax treatment than the trust would. However, if we have a situation where you have minor children, or if you have a special needs beneficiary, or if they're just not financially responsible, then you may want to name the trust for the benefit of said individual for their portion of that IRA. And we give you very specific language for how to do that so that it's very clear what portion is going to the trust for that beneficiary. So it's going to kind of depend on your circumstances, and we can advise you about that separately. And then if not, does the IRA not pass to the trust but to multiple beneficiaries? So it's really going to be structured based on the beneficiary designation that you have on record with that financial institution. And that's going to kind of trump all other hopes and dreams and thoughts about where it should be going in your trust. It's going to depend on what you filed with that financial institution. So it's always good to check in on those, make sure you've got those properly updated.
Yeah. And just for those that aren't aware, a see-through trust, when you have an IRA, there are requirements of the IRA being distributed. So for example, when husband dies and leaves the IRA to a spouse, the spouse rolls it over. She can wait to the appropriate required distribution age and take it out. That has been eliminated for any beneficiary that is not the spouse or certain requirements. So generally children must take it out within a 10-year period. So for example, if the father dies, leaves everything to the mother, then she dies and leaves it to the 3 children. If she leaves it outright to them, they get the choice on day one. Do they want to take their share? So let's say there's a $900,000 IRA and there are 3 beneficiaries. So child 1 might say, okay, my share is 300,000. I want to take it all out today and spend it. So they're going to be hit tax-wise, because remember, the money put into that IRA was all pre-tax. So when it comes out, it's taxable. So the question is, do you feel comfortable with them making that determination or not? And as Cassidy mentioned, if you have a beneficiary that has special needs, has addiction issues, spending problems, maybe as a minor, that is not a good option. Okay. The other option that beneficiary getting their money outright is that they can choose to distribute it over a 10-year period. And this is a good thing because they might want to do tax planning. So child number 2 might say, hey, I plan on retiring in year 4 of this. So I'm going to take the required minimum that I'm allowed to take for years 1, 2, and 3. And maybe in year 4, when my tax rate goes down because I'm not earning my salary, that's a good year to pull out the rest of it so that I have a less tax base. And so they can play around with it. But the longest they're able to stretch it is 10 years. And then there's some other requirements with the Secure Act, which governs these, is when you have minors too. So usually we recommend naming the trust as a beneficiary when you have minors. And we would recommend, for example, the Smith Family Trust for the benefit of child 1. The Smith Family Trust for the benefit of child 2, as Cassidy mentioned, naming the specific beneficiaries. So that way, when we look at child number 1, we can go, okay, child number 1 is 15 years old. So there's a delay on that until they're 18. And then at 18, their 10 years starts. So if you have then child number 2, who's only 12 years old, they're going to have a different time frame on that 10 years. So that's why it's very important to name specifically the beneficiaries, the Smith Family Trust for the benefit of child 1, for the benefit of child 2, for the benefit of child 3, versus just the Smith Family Trust. So, and then you have, and that's where it can still see through, means the money comes out of the IRA into the trust, and the trustee is then required to distribute that money to the beneficiary. Okay. And in some cases that's okay, especially, you have kids, they're of college age, the trustee is going to maybe using that money for them anyways. But there are other situations, like if you have a special needs beneficiary, maybe you have a child with some addiction issues or other reasons not to give it to them, the trust can be drafted as accumulation, meaning although the IRA says, a portion of it must be paid to the trust in this year, that the trustee is not then required to distribute it out. So that obviously has a little bit more adverse tax consequences, because in that case, the money from the IRA is staying in the trust, and the trust hits its highest tax brackets, usually about almost $13,000 of income. Where if that IRA had been distributed to the trust and then that distribution made to the beneficiary would report that income on their tax return, which may have a lower income tax rate. So we have to look at all these different situations with regard to your family. And that's how the see-through accumulation, all those provisions, and who we recommend to be your beneficiary is determined. So, and it's something that, is going to change over time potentially, especially if you have minor children and then they become adults, and so forth. And a lot of it also depends on the money, because, I'll have clients that'll come in and maybe they have 150,000 and they're like, okay, if my 18-year-old pulls it out, they have 100,000. Okay, worse, maybe they're going to buy a car, who knows? Okay. Versus if you're leaving them, we have some clients that have like $1.5 million, 2 million and higher in their IRAs that, if you're naming the 18-year-old directly, they may blow off college, they may blow off, choices and go, motorcycle around Europe or something that might not be something that you want them to do. So, it depends on multiple factors, and that's, we want to know more about your family and everything. The next questions are about real estate specifically. So, okay, and the questions are, let me take one step back, because there's questions about Prop 13 and Prop 19. And so let's be clear on exactly what the differences are. Prop 13 is for everybody in California that when you buy a property, or, generally you buy a property, the most that the property taxes can be increased annually is 2%. That's what Prop 13 deals with. Prop 19 deals with the transfer of ownership from what is excluded and when can children or grandchildren be able to keep some or all of the parent's property tax basis. So they're actually two different things. So the first question is, can I leave my house to my grandson as his primary residence and still maintain Prop 13 property taxes? Okay, so this is a transfer from grandparent to grandchild. Primary residence is a good thing. Okay, so so in general, when you're transferring property from parent to child or parent to grandchild, and it's the grandparent or parent's primary residence, we're going to look at what property tax basis are the parents paying. So let's pretend that they're paying property taxes on $300,000 level. If that property's fair market value is $1 million, if it qualifies, then the children get the 300,000 plus the next million. And they would then get to keep the $300,000 limit. So in this case, if the property is only valued at $1 million, so they basically have up to a fair market value of 1.3 million, can still be taxed at that $300,000 limit. Okay. But let's say that they're paying property taxes at a $300,000 limit, but the property is worth $2 million. Then you have 300,000. We add that million. So the first 1.3 million of that property is going to be taxed at 300,000. But the difference between 1.3 and 2 million, the 700,000, is going to be increased. So when the beneficiary receives it, they're going to pay property taxes on $1 million level. The original 300,000 plus that overage. So they're still getting a good deal. They're still not paying the full property taxes, but they're not 100% keeping mom and dad's property. Now we have a whole different situation when you're talking grandparent to grandchild. And Cassidy's really good at this, so I'm going to let her explain it.
So grandparent to grandchild is a kind of a little special beast in this, I don't know, call it a word problem, familial situation. Basically, because what we have to have in play here is the parent of the grandchild and direct child of the grandparent has to be deceased, and also the spouse of that parent, if there was one, so that they would not get a parent to child benefit from a different piece of real property. And that's kind of where the nuance lies, is their parent has to be gone in order for this to work for a grandparent to grandchild situation. But otherwise, the circumstances are the same. So yes, that's the special conundrum there. So it's not a great situation to be eligible for it from a grandchild. Okay.
Yeah. So we always have to look at who's still alive. And sometimes even though the child is alive, the grandparent the grandchild's one of their parents is gone, it has to be both of their parents that are gone. And that's usually where we get hung up. Okay. The next question says, does Prop 19 say that only $1 million worth of house can maintain Prop 13 tax? So no, that's where I said we look, if it is a legitimate parent to child or parent to grandchild, we take what is the value that the parent has. If they're paying property tax, again, at $300,000 limit, it's 300,000 up to the next, add $1 million on top of that. So for at 300,000, the first 1.3 million of the fair market value of the property will stay at the $300,000 limit. Or if if parents are paying property taxes at a $500,000 limit, then it goes up. The first $1.5 million of that property is going to be subject to the $500,000 limit. Anything above that will get reassessed. So in a lot of situations, it's still quite beneficial to be able to do that. And going back, we've mentioned primary residence multiple times. It does only apply to the parent's primary residence. It used to apply to secondary, whether it was a secondary home, commercial property, raw land, different things like that, but that has been completely eliminated. So if you're leaving a piece of real estate that is not your primary residence to anyone other than your spouse, then the property tax will be reassessed based on the fair market value of that property on your date of death. Okay. Cassie, you want to take that? There's some more property. Yeah. Understand?
Sure.
Yeah.
All right. This one says, I understand how Prop 19 changed the inheritance laws regarding taxes when a parent dies and leaves property to their heirs. My question is, does an LLC protect from that taxation, which is very possibly unaffordable for their heirs?
Yes.
Okay, so this one's a little bit complicated because it has to do with if it's a full transfer or not. I think it has to do with who owns the LLC and things. There's a lot of different parties at play here. We have to do who owns and who benefits from the LLC versus who is transferring the property to determine if it's actually been enough of a transfer to warrant reassessment. So that's the first thing.
Yeah.
But an LLC in and of itself isn't going to protect from that. It's more complicated than that. And especially if it's not a primary residence, then it's not going to protect from it at all.
Yeah, and most of the time we don't put a primary residence in an LLC.
Most of
But
the time, yes.
okay, so but the LLC rules are different. So generally, you can transfer no more than 50% of an LLC interest without triggering the property tax reassessment. So what some people have been doing is, okay, so let's say that mom has a rental property. Okay. If mom puts the rental property in an LLC, she's 100% owner before and 100% owner after. So she's considered the original transferor. Okay. So there is no change of ownership because it's treated as if it's one and the same from her to her. Okay. Now you have the property in the LLC. If mom transfers no more than 50% of her interest in that LLC to anyone else, there is not going to be a property tax trigger at that point. Okay. So maybe mom wants to give 49%, 50% of that LLC interest to her child. So no property tax change happens at that time. However, if the child and the mom remain the owners of that LLC, when mom dies in the future, and that property transfers at that point, now more than 50% of that property is going to be transferred. So generally what we would do, and that would trigger full reassessment of the property. So generally what we would do is mom puts the property into the LLC, makes a gift of no more than 50% to the child, and then the LLC is actually terminated. And the property comes back, and let's say mom owns 51% in her trust and child owns 49% in their trust. Okay. So then mom could, an easy thing to do is mom could gift 1 or 2% to the child at that time, let's say, and force a reassessment. But if you're only transferring 1 or 2%, that's not a big deal. Okay. So make that gift, pay the increased property tax on the 1 or 2%. Now we have child owning 51% and mom owning 49%. So now they can think about, well, wait, let's go ahead and create a new LLC. And we go back to now the original owners, the original transferors in the LLC are mom and child. 49% mom, 51% child. Or yes, so then there's no property tax change at that time because their interests are proportional to what they put in. Now, when mom dies, and she's only transferring 49% of the LLC to her child, there's no property tax change because we have less than 50% change. So in that case, we were able to get 98, 99% of the property transferred to the child, keeping that same property tax basis. Okay, but then if the child leaves that property in that LLC, and when they die and they give it to their children, now you're going to have a problem. So the child would then have to terminate the second LLC, put it in their name alone, and go forward. So that's the way to avoid probate. And generally, we recommend that you do that over a long period of time. That is not something done within a 2-month period. You also have to look at, although we may be saving property taxes, we're not getting a basis adjustment in the property. Because so when mom gave that first 49%, she's made a gift to her child. So when she gave the 49%, the child takes her cost basis in the property. And if that has been a rental or a commercial property, the basis may be very low if mom had been depreciating it all of her life. So that does not get a basis adjustment when mom dies because she's already given it away. And then, the same thing in our example, if mom gives 2% after they pulled it out of the LLC, that is another gift. The child takes the basis of the parent because it's a gift. So then when we go up and we go, okay, now we're in the second LLC and mom dies and she gives the 49%. Yes, the 49% will get a basis adjustment, but you're going to need to do a discount valuation because there is a lack of majority interest. There's lack of being able to sell it because, most people do not want to buy a minority interest in something that they don't have control over. So if you had $1 million property, mom's interest is generally not valued at $490,000 for 49%. It's usually going to take a 15-20% discount on that value for the lack of marketability. So you'll get a basis adjustment, but there'll be it won't be the full amount. So when you're looking at these things, you need to determine, is this a property that we're going to keep in the trust or, within the family for years and years and years to come? Because in that case, keeping the property tax low is a good thing. But, if your child is going to turn around and sell it, you generally want them to have a higher cost basis so that when they sell it, they're paying less capital gains. So you got to look at the different areas of play. And then it gets a little bit more complicated when you have, let's say, 3 or 4 owners, because then, you still have to go back and you have to do the calculation of who were the original transferors, how much has been transferred over time and at what point do we get to that 50%? So
the other thing I think people need to be careful of is making sure to do this before we have incapacity issues and before we have hopefully end of life issues, things like that, because if it gets disrupted in the middle of this process, it can cause some problems too. So planning ahead of time is always better than not. So just something to think about when thinking about taking this action as well.
The last question related to that is, are there other restrictions like renting a room or rooms, etc.? And I think I haven't dealt with that specifically, but I would imagine that if it's the mom and dad's, mom's primary residence, but she rents out one room to a third party, that you'd probably do a pro rata that, maybe only 80% of the house is available for that because part of it is considered like a commercial property. We'd have to look at the situation a little bit more. Okay. So That is it for all of the pre-submitted questions, but it looks like we do have a couple that have come through. So I'll let Cassidy go ahead and start.
Okay, so first one I'm looking at says I have a trust, but I haven't funded it yet. What's the first thing I should focus on? So my preference is, of course, do the deed as you do the trust, because I think that should be taken care of first and foremost. It's likely most people's largest asset. And then from there, I typically break it down by, okay, let's go largest value to smallest, because those are going to be the things that we have more risk with keeping outside of the trust. So it's going to depend if that's retirement or normal investment accounts, things like that. If you have a group of accounts at a certain bank, that's always helpful because you can go get a bunch checked off your list all at once. And then also reaching out to, say, retirement fund administrators or life insurance. It's kind of a process with them because you have to get paperwork from them and get it signed and then send it back. So even initiating that contact to say, hey, I'm looking at updating my beneficiaries, that can be done while you're in the process with some of these other things. But I would say real property first, and then look at highest values next, and then kind of go there and break it down one step at a time. And the good thing is we give you a funding checklist and want to make sure that you have check-ins with us every few years to see if anything's changed. Have you done all your homework? All of that kind of stuff. So it's a process, but it usually can be done rather efficiently if you're careful. So, okay.
And the next one says, is there a downside to putting everything I own in my trust? Are there certain things that are smarter to be kept outside? So the downside depends. I'd say the main downside is taxes. Okay. So the main things that should always be in the trust are your real estate, your business interest, your checking, savings, CDs, mutual funds, investment accounts. We assign your personal property, those types of things. The things that are usually held outside the trust in your name alone are your personal cars, if they are of a lower value. Your everyday cars that are depreciating, your Toyotas, your Fords, things like that, your Hondas. If you have a Ferrari or something like that, that might be a little bit different, when you have the higher value that we might want to put those in the trust. Okay. You have, a $300,000 RV or boat. But, if you just have, a regular $5,000 ski boat or something like that, we're not usually, those aren't a big deal because, like I said, they're depreciating. They're usually holding their value, and that's fine. The things that are usually outside the trust, well, first of all, your life insurance is usually owned by you, but then we look at your beneficiary. Almost always, I recommend that you name the trust as the beneficiary of your life insurance, because that way it provides liquidity. It also provides that if, we go through probate so much on life insurance policies and retirement plans, because we'll have husband and wife will name each other and they will not name a backup. So then we have the first spouse dies and the second spouse does not update it. So I like to name the trust, because if husband and wife, if the insurance is on husband and his wife dies first, we don't care because the trust is already named as the beneficiary. But if the wife is alive, 9 times out of 10, she gets everything in the trust anyways. So it's already there for her. And if she has predeceased the husband, when the insurance pays out to the trust, now it's there for the beneficiaries. It also provides a lot of liquidity for the beneficiaries, which can help a lot if the bulk of your estate, like if you have a piece of real estate and then some liquid assets, and one of the children wants the house, but there's not enough assets to equalize the other kids. If you name the trust as the beneficiary of your life insurance, now you've added a lot more cash there that is able to equalize those benefits. So that can be very helpful. It's also obviously good when you have minor beneficiaries as well, since we can't, leave a bunch of money to a 10-year-old. The other thing that is outside the trust is retirement plans, your 401k, 403b, IRAs, Roth IRAs. They're legally not allowed to be owned by the trust. But as we discussed before, you can name the trust as the beneficiary, or you can name individuals as the beneficiary. And there's like we talked about before, a lot of income tax situation there. It depends on how we set up the trust, like we mentioned, see-through accumulation, who your beneficiaries are, and things like that. But generally, otherwise, I would put everything into your trust, so that upon your incapacity, it's there, and upon your death, that we're avoiding probate on all of those things.
Okay, so this kind of piggybacks on the conversation we were just having. My mom had a trust, but we are still dealing with probate. Why would a trust go through probate? Isn't the point to prevent probate? Yes, it is. But very commonly, either people don't do the homework that we've given them to put bank accounts and investment accounts in the trust, or like Paula was talking about, they haven't updated a life insurance policy or a retirement account to have beneficiaries after the first spouse has passed. I have one right now where the spouse passed and predeceased, and then we didn't have any children. So there was no backup beneficiary. And unfortunately, we thought we were going to get through with a small estate affidavit. It was less than the probate threshold. And then we found a second one. And here we are going through probate for only about $250,000. And it's very unfortunate because it's going to take a substantial amount of time and money to go through that process. So yes, it is, the point is to avoid probate, but it has to be done right and checked up on and not just left on the shelf to get dusty, to make sure that we continue to fund assets to it and continue to update those beneficiaries. I always say our check-ins are great, but if you need a more recent check-in than your 3 years, is it death, divorce, marriage, birth, all of those different things, major life events, is a reason to come in and have a conversation or at least a quick phone call and say, hey, do I need to do anything here? I bought a new house. Well, is it in the trust? If it is, great. If not, we should probably do a deed for it. So all of these things come up, and they're a reason to check in and just kind of get your financial house in order and make sure things are in the trust. So.
And um, when you're a client of ours, we do those reviews every year for you, complimentary. And, I would say probably at least once a week, I get an email or a call. I changed banks, or I bought a new house. I know I'm supposed to do something, and we're happy. Please call us. We don't charge you for that, because it usually takes us a second just to be like, here's exactly how your title should be when you're buying that new house. Or, and we want you, when you're buying that new house, take title during the purchasing process, because you are always asked during escrow, how do you want to hold title to your property? It's best to let them do it. You're already paying for the escrow company to prepare the deeds for you. If you take it, for example, as husband and wife or in your individual name, and then you call us after escrow closes, we're going to charge you to prepare a deed. So call us before. We'll tell you exactly how it's supposed to be, and we won't charge you for that. Escrow will prepare your deed for you to make it a lot easier. Okay, so the next question says, can I prevent someone from contesting my will? I'm going to assume that applies to the trust. As well. I don't want them to sue and cause problems with my family. Well, every time we do a will and a trust, we do include a no contest clause. There are provisions in there that if certain things are done, and it is considered a contest. But there are certain things that are not considered a contest. So, well, number one, you can never prevent someone from suing. Everybody's allowed to sue. Whether they're going to win and whether they have a case or not is a whole different story. But sometimes people like to do that because they think that they can force a settlement. So you have to look at those things. But generally, if, for example, if we see this a lot. So let's say that mom had done her trust, okay, and it left everything to all three kids. And then mom starts to go downhill, maybe has dementia, and then all of a sudden, some attorney, we don't do this, will allow mom to create an update to her trust, and maybe she doesn't have capacity. Then that could be actually challenged. But the person challenging it and contesting it has to prove when mom did that amendment, she didn't have capacity. If you lose, you could potentially lose everything in your trust. If you win, you knock out that amendment and you look at the prior ones. And I say, like we've had clients come in, and just from generally talking to them, asking them who their family is, where do their kids live? That's the reason. One of the reasons we start asking you about your family is to find out, do you know who these people are, your natural heirs, who would be, what are your assets and things. And in cases, because our job would be to protect that person, we'll have them go out and get what's called a mini mental. So we want them to go, if there's going to be any question and it could potentially cause a conflict, let's go have them get evaluated with a neurological exam, so that if that challenge does come up, then we have the backup that says at this time they did have capacity. And so sometimes we'll do that, and then there are other times where we've just said, I'm sorry that we don't feel that it's good enough, and because we don't want to be involved in that, and that there could be some type of undue influence or something if the person does not have full capacity.
Yeah, I would say probably one of my harder times in dealing with clients with lack of capacity is when they're just rehearsed. You can tell that someone's prompted them to make a decision and they're reading off the same piece of paper but can't have an otherwise coherent conversation around what they want, what their goals are, and things like that. And it's hard to have to say, no, I don't feel comfortable doing this, but also we we can't do that to people. It's terrible. And I've seen it done before when people get in front of us and it's not great. So
Yeah. Well, and then, I always encourage clients, if there's a reason, let's say you leave 80% to one child and 20% to another, or you cut out a child or something like that, which you're perfectly able to do. You do not have to leave your assets equal to your children. You don't even have to leave them to your children. You can leave them to whomever you like. But generally, when you're dealing with your family members with the closeness, like a child, not like an extended family member, have the conversation with them. Let them know. I mean, most of the time, I think that the kids should know that why they're disinherited. But, I'll have clients say, I want to leave more to child number one because they have maybe a special needs child, or maybe they have special needs themselves and they need more money. They're not going to be able to work. But child number two is a doctor and has a good income or something like that. Have those conversations, and explain what your reasoning is on how you set that up, so that they, one, hear it from you and they're not shocked when you pass away, because they're already dealing with the loss of potentially a parent or other loved ones, but then to have them maybe disinherited and have that second punch of, oh, mom didn't love me as much, or things like that. And that's what causes a lot of the fighting. So be straightforward with the people and explain, this is what my intention is, this is why I'm planning on doing it, so that there isn't these fights after you're gone.
yeah, I think that's a good idea. Okay, so the next question here says, I don't want my sister to know that I died. Can I prevent her from being notified of my death? And does she have a right to see my trust? Um, Honestly, it's not the first time I've seen something like that. I see it relatively regularly that they just don't want certain people to know that they passed away or they shouldn't get a copy of my trust, different things. Well, there are certain people that are entitled to a copy of your trust should they ask for one. So after someone passes away, there's a code section that requires notice to go out to the heirs and beneficiaries. So heirs meaning those who would inherit at law if you didn't have any planning in place, and then beneficiaries, those named in your estate planning documents that are going to receive your assets after your passing. Those two groups of people are required to get a notice that the person has passed away, either they did or didn't have a trust. All of these different things are included in that notice that we send out. And commonly we send a copy of the trust with that, just so that we can start what we call a statute of limitations, basically for how long they have to be able to contest that planning that you have in place. And it starts that 120-day timer. If we don't give them a copy of the trust, if you want them to have to ask for it, fine, we can do that too. But it does lengthen that time frame a little bit, because then we're not getting that trust out to them right away. Okay, so can we specifically not provide notice to someone? It depends if they're an actual heir to you. So if you're married and you have kids, is your sister going to be entitled to notice? No. But if you're unmarried and you don't have any kids and your mom's deceased and you don't have a dad either, like well, then your next of kin, your heir is your sister. So she would be entitled to notice of your passing. So it's going to depend on the family situation that you're in. But yeah, if we see this where people don't want them to have a copy of their trust, things like that. And it really depends on that situation. And if they are an heir and a benefit or a beneficiary, they are entitled to a copy of your trust if they ask for it.
Yeah. And most of the time, like I said, we can put in your trust, I specifically disinherit this person. They're just, if they're an heir at law, they're entitled to a copy of it. And, very rarely do people, in our case, that they come back and they don't understand why they were cut out. So, so that's a good thing. So, and that's where we will take diligent notes at the meeting. And, I guess we get really nosy because, if it comes, like, if you have two children who are entitled to it, but you cut one of them out, I'm the one that's going to be your voice, afterwards. So we take, Cassie and I will take the notes and say, I'm, disinheriting them for this reason. We don't necessarily put it in the trust, but it'll be something that we'll keep in our notes and say, these are the reasons that you chose to do it. You haven't seen them in 5 years. They, I don't know, they moved, I don't know, whatever reason it is. And so that if it ever does come up, then we can be brought in to explain why you made that choice, that you weren't necessarily under undue influence. When you made that choice, it was your conscious decision to not include that person.
Well, and sometimes it's for a good reason too. I have one recently where it was just that they wanted to give an additional asset to one of the kids because they don't have the same financial advantages that the other child has gotten from their own career. And so they wanted to give him a little more. And they were very transparent with the family as to this is what they were trying to do. And so I just took diligent notes of, okay, well, if you split things 50-50, he can still have this asset as part of his 50%. This, we understand that, but we want him to have his 50% plus this. And I was, okay, as long as we've had that conversation, I'm happy to document that as still part of your wishes, that we want to give a little extra here.
Yeah.
So.
Yeah. Well, that concludes all our questions. If you have any specific questions for yourself, then please, give us a call. We'll schedule an appointment and talk to you about it. Our next presentation is our webinar is on March 18th, 2026 at 12 p.m. as well. Here is a QR code if you want to register for this. It's called Spring Cleaning Your Estate, Refresh and Organize Your Plan, where Cassidy or I will go through and talk to you about, how do you keep things updated? It's been a couple years. Have your kids grown? Do did the person you name as trustee or successor trustee, have they died? Do you still go to the church that you left as a beneficiary, of some of your money, different things like that. What has the law changed? Where have your accounts changed? Just taking a look. Tax time is a great time to do that. So we thank you for attending. We're going to go ahead and send out a replay of this and as well post it on our website as well as our YouTube page. But again, if you have any questions that you want to answer directly, please feel free to reach out to either Cassidy or myself, and we'd be happy to have a private consultation with you. Thank you very much.